The Constitution Bench of Supreme Court upheld validity of Section 6A of Citizenship Act of 1955. So what is this act? ये प्रिस्क्राइब करता है 5 ways जिससे कि हम सिटीजनशिप एक्वायर कर सकते हैं. फर्स्ट इज बर्थ, डिसेंट, रजिस्ट्रेशन, नेचुरलाइजेशन एंड इनकॉर्पोरेशन ऑफ टेरिटरी. नो प्रोविजन फॉर डुअल सिटीजनशिप. डुअल सिटीजनशिप किस कंट्री में दी जाती है? जैसे कि यूएसए, यूके, पाकिस्तान एक्सेट्रा में दी जाती है. नाउ व्हाट इज दिस सेक्शन 6A? सो special provision which was added through Citizenship Amendment Act of 1985, which was like the aftermath of memorandum of settlement with the ASU, and this was known as Assam Accord between the then central government and the leaders of Assam movement. It conferred citizenship to those who migrated from East Pakistan, now Bangladesh, to Assam from January 1st, 1966 until 24th March 1971 upon completion of 10 years from date of detection as a foreigner. तो जो लोग इस स्टेट के बीच में इंडिया में आए हैं बांग्लादेश से, इनको सिटीजनशिप देने का इसमें प्रावधान है. सिटीजनशिप अमेंडमेंट एक्ट ऑफ 2019 अमेंड्स सिटीजनशिप एक्ट ऑफ 1955. एंड रिलेटेड न्यूज़ में आ रहा है कि जो फॉरेन ट्रिब्यूनल्स होते हैं वो क्या. सुप्रीम कोर्ट ओवरटर्न द डिसीजन ऑफ असम फॉरेनर्स ट्रिब्यूनल एंड डिक्लेयर्ड अ रेसिडेंट ऑफ स्टेट एज इंडियन सिटीजन. Foreign tribunals are quasi-judicial bodies established under Foreigners Tribunal Order of 1964 by central government according to Section 3 of Foreigners Act of 1946. Authority: only these tribunals have power to declare a person as a foreigner, thus being excluded from NRC in Assam does not automatically classify a person as a foreigner. It has power of civil code under Code of Civil Procedure of 1908. Citizenship Amendment Rules of 2024. Ministry of Home Affairs has amended Citizenship Rules of 2009 and notified Citizenship Amendment Rules of 2024 to enforce the Act, the CAA 2019. So what are the key highlights of these rules? Eligibility: to apply for citizenship by registration or naturalization, one must be person of Indian origin, married to an Indian citizen, minor child of an Indian citizen, person whose parents are registered as Indian citizen, person or either of his parents was a citizen of independent India, registered as an overseas citizen of India, कार्ड होल्डर. OCI कार्ड होल्डर अगर है तो उनकी एलिजिबिलिटी इसमें दी गई है. अदर क्वालिफिकेशन फॉर सिटीजनशिप बाय नेचुरलाइजेशन: प्रेजेंट्स an affidavit verifying correctness of statements made in application and an affidavit by an Indian citizen to testify the character of an applicant. तो एक इंडियन सिटीजन की टेस्टिमनी लगेगी. फिर adequate knowledge of one of the language listed in 8th schedule. Then proof of nationality में applicants जो है 20 different documents यूज़ कर सकते हैं as a proof to entry into India, including visas, residential permits, census slips, Aadhaar card, etc. Renouncing citizenship of another country: declaration saying citizenship of his country shall stand renounced irrevocably if application for Indian citizens is approved. Okay. Authority to which application may be made. Under Section 6B of Citizenship Act of 1955, applications shall be made in electronic forms to empowered committee through district level committees as notified by central government. CAA 2019 4 conditions: illegal immigrants who fulfill 4 conditions will not be treated as illegal migrants under the act. They are Hindus, Sikhs, Buddhists, Jain, Parsi or Christians, and they came from Afghanistan, Bangladesh or Pakistan, entered India on or before December 31st, 2014. They are not in certain tribal areas of Assam, Meghalaya, Mizoram and Tripura, included in 6th schedule of Constitution. Areas under inner line permit, that is Arunachal Pradesh, Mizoram and Nagaland. Central government exempted the said migrants from adverse penal consequences of passport entry into India Act of 1920 and Foreigners Act of 1946. Naturalization period reduced from 11 years to 5 years for the above category of migrants. OCI Act provides that central government may cancel OCI registration on 5 grounds. जैसे कि अगर आपने फ्रॉड से रजिस्ट्रेशन कराया है, अगर आप कॉन्स्टिट्यूशन को डिसअफेक्शन दिखाते हैं, engaging with enemy during war, then necessity in interest of sovereignty of India and security of state or public interest, if within 5 years of registration OCI has been sentenced to imprisonment for 2 years or more. What is OCI? Who are OCIs? Overseas citizens of India. Ministry of External Affairs has dispelled concerns regarding OCI card holders being reclassified as foreigners, confirming that the existing OCI rules remain unchanged. कौन है OCI card holders? OCI scheme introduced by amending the Act of 1955 in 2005, and foreign military personnel either in service or retired are not entitled for grant of OCI. Person of Indian origin and OCI card holders have been merged under one category in 2015. Eligibility क्या है? Any foreign national except national of Pakistan and Bangladesh, citizen of India at the time of or at any time after 26 January 1950, eligible to become a citizen of India on 26 January 1950, who belong to territory that became part of India after 15th August 1947. Child और ग्रैंड चाइल्ड और ग्रेट ग्रैंड चाइल्ड और सच सिटीजन, मतलब ये तीनों कैटेगरी में जो लोग हैं उनके अगर आप बच्चे हो, ग्रैंड चाइल्ड हो या ग्रेट ग्रैंड चाइल्ड हो, आपको आपको OCI कार्ड होल्डर बनाया जा सकता है. हु इज़ माइनर चाइल्ड ऑफ सच पर्सन्स मेंशन अबव, हु इज़ माइनर चाइल्ड एंड हुज बोथ पेरेंट्स आर सिटीजन्स ऑफ इंडिया और वन ऑफ द पेरेंट इज सिटीजन ऑफ इंडिया. या तो दोनों पेरेंट्स हैं जो इंडियंस हैं या फिर एक पेरेंट जो है इंडियन सिटीजन. ओके. फॉरेन origin spouse of Indian citizens or OCI holder whose marriage registered for at least 2 years before presentation of application. Benefits क्या क्या होता है? मल्टीपल एंट्री, मल्टीपल पर्पस, लाइफ लॉन्ग वीज़ा, ठीक है. इक्वालिटी विद NRIs इन सर्टन फाइनेंशियल, इकोनॉमिक एंड एजुकेशनल मैटर्स. एक्सेप्शन क्या हो जाता है कि अगर आपको एग्रीकल्चरल या प्लांटेशन लैंड लेनी हो तो आप नहीं ले सकते हो. और इंटर कंट्री अडॉप्शन ऑफ इंडियन चिल्ड्रन, ठीक है, इसमें थोड़ा डिसएडवांटेज रह जाता है. एलिजिबल फॉर ग्रांट ऑफ इंडियन सिटीजनशिप अंडर सेक्शन 1G ऑफ सिटीजनशिप एक्ट ऑफ 1955 आफ्टर कंप्लीशन ऑफ 5 years ऑफ एज OCI card holders. Condition: he has resided in India for 1 year out of 5 years before making application. Eligible to enroll in national pension scheme at par with non-resident Indian. रिस्ट्रिक्शंस क्या होते हैं? डज नॉट कन्फर पॉलिटिकल राइट. कोई पॉलिटिकल राइट नहीं होता है वोटिंग से रिलेटेड, और कॉन्स्टिट्यूशनल पोस्ट नहीं होल्ड कर सकते हो आप, और लोकसभा, राज्यसभा, लेजिस्लेटिव असेंबली, लेजिस्लेटिव काउंसिल के मेंबर नहीं बन सकते. विद रिकॉर्ड टू इक्वालिटी ऑफ अपॉर्चुनिटी इन मेंबर्स इन मैटर्स ऑफ पब्लिक एम्प्लॉयमेंट में भी आपको उसमें सेम ट्रीटमेंट नहीं दिया जाएगा. पब्लिक सर्विस positions in union and state affairs except for specific post designated by central government through special orders. Special approval is required for research, mountaineering, missionary activities, journalism, and to visit restricted protected areas. Okay. Reservation and affirmative actions. USA से रिलेटेड न्यूज़ है, तो अफर्मेटिव एक्शन क्या होते हैं? पॉजिटिव स्टेप्स टेकन टू इंक्रीज रिप्रेजेंटेशन of certain historically oppressed groups in the society in the areas of education, employment, etc. So India और USA के affirmative actions में क्या डिफरेंस है? कॉन्स्टिट्यूशन ओरिजिन, कॉन्स्टिट्यूशन ने एक्सप्लिसिटली इंडिया में मेंशन करके रखा है affirmative एक्शन को, जैसे कि आर्टिकल 15 में दिया हुआ है, या फिर जो लैंग्वेज वगैरह से रिलेटेड हमने दिया. फिर USA में कॉन्स्टिट्यूशन में नहीं है, बट इक्वल प्रोटेक्शन क्लॉज ऑफ 14th अमेंडमेंट हैज़ बीन इंटरप्रेटेड टू परमिट अफर्मेटिव एक्शंस. पर्पस टू रेमेडी हिस्टोरिकल डिस्क्रिमिनेशन अगेंस्ट ग्रुप्स सच एज अनटचेबल्स. और यूएसए में क्या है? टू फाइट डिस्क्रिमिनेशन अगेंस्ट माइनॉरिटी ग्रुप्स एंड वुमेन. टारगेटेड ग्रुप्स कौन से होते हैं इंडिया में? सोशली एंड एजुकेशनली बैकवर्ड क्लासेस एंड इकोनॉमिकली वीकर सेक्शंस. यूएस में अफ्रीकन अमेरिकन, हिस्पैनिक्स, एशियन अमेरिकन एक्सेट्रा. सिस्टम क्या है, कोटा सिस्टम रहता है, और यूएसए में डाइवर्सिटी इक्विटी एंड इंक्लूजन प्रोग्राम्स रहते हैं। प्रोविजन आर्टिकल 15(4) एंड 16(4). इसके अलावा भी कुछ आर्टिकल्स हैं जो कि स्टेट को रिजर्वेशन देने के लिए इनेबल करते हैं। आर्टिकल 15(4) में क्या लिखा हुआ है, इनेबल्स स्टेट टू मेक स्पेशल प्रोविजंस फॉर एडवांसमेंट ऑफ SC/PCs और सिटीजन्स और फॉर SC/ST। तो इसमें 3 कैटेगरी का दिया हुआ है। 16(4) में क्या बोलते हैं, इनेबल्स स्टेट टू मेक एनी प्रोविजन फॉर रिजर्वेशन ऑफ अपॉइंटमेंट और पोस्ट इन फेवर ऑफ एनी बैकवर्ड क्लास ऑफ सिटीजन्स नॉट एडिक्वेटली रिप्रेजेंटेड इन सर्विस अंडर स्टेट। ठीक है, बिगैन थ्रू an executive order in 1961, later Civil Rights Act of 1964 enacted to give it a legal backing। तो ये बेसिकली स्टैट्यूटरी हो गया यहाँ पर, और यहाँ पे कॉन्स्टिट्यूशनल है। ठीक है, फिर अपर सीलिंग क्या है, अपर सीलिंग 50% है, जो कि सुप्रीम कोर्ट ने सेट करी थी इंदिरा साहनी केस में, और यूएसए के केस में कोई अपर लिमिट नहीं है। नेक्स्ट टॉपिक है सब क्लासिफिकेशन ऑफ शेड्यूल्ड कास्ट। सुप्रीम कोर्ट इन स्टेट ऑफ पंजाब एंड अदर्स वर्सेस तविंदर सिंह case held that sub-classification of scheduled caste is permissible to grant separate quota for more backwards within the SC category. Scheduled caste notified under Article 341(1) are heterogeneous groups of castes, races, tribes with varying degree of backwardness. Article 341(1) precedent to specify caste, race, tribes as SCs for any state or UT. Subclassification within SCs does not violate Article 341(2) because castes are not per se included in or excluded from the list. Article 341(2) Parliament may by law include or exclude any caste, race, tribe from the list of SCs by passing a law. Scope of subclassification. Objective of any form of affirmative actions including subclassification is to provide substantive equality of opportunity for backward classes. Substantive equality refers to principle that law must account for different backgrounds and historical injustices faced by persons or groups. State can subclassify based on inadequate representation of certain castes. However, state must establish that inadequacy of representation of caste is because of its backwardness. State must collect data on inadequacy of representation in services of the state. State cannot act on its whims or political expediency, and its decision is amenable to judicial review. Court clarifies that while allowing subclassification, the state cannot earmark 100% reservation for a subclass. Court noted that subclassification was permitted for SCBCs under Article 342A introduced in 2018, which empowers the President to prepare list of SCBCs. Judicial pronouncements. Indira Sahni case excluded creamy layer within OBCs. E.V. Chennaiya versus State of Andhra Pradesh 2004 subclassification of SCs amounted to tinkering with presidential list and therefore violated Article 341(2). Jarnail Singh case application of creamy layer concept to Article 341 and 342 does not tinker with presidential list. Uniform Civil Code. Recently, Chief Minister of Uttarakhand announced the Uniform Civil Code will be implemented in state from January 2025. Background. Pre-independence Lex Loc report in uniformity in codifying Indian law related to offences, evidences and contracts. Muslims and Hindus' personal laws should not be codified. B. N. Rao Committee codified Hindu law which would give equal rights to women. Post-independence Special Marriage Act. 4 major enactments of Hindu laws: Hindu Marriage Act of 1955, Hindu Succession Act of 1956, Hindu Minority and Guardianship Act of 1956, Hindu Adoption and Maintenance Act of 1956. UCC, it refers to uniform system of personal laws applicable to all irrespective of their religion. Matters in the scope of personal law include marriage, divorce, maintenance, inheritance, adoption and succession of property. Article 44 under Part 4 of Constitution directs the state to secure to citizens a UCC throughout the territory of India. Currently, Indian personal laws are complex, with each religion adhering to its specific laws. For instance, Hindu Succession Act of 1956 governs Hindus, Sikhs, Jains, and Buddhists. Muslim personal laws govern Muslims. Indian Succession Act of 1925 applies to Christians and Parsis and Jews. In Goa, a form of common civil code is in practice under Portuguese Civil Code of 1867. Places of worship Special Provisions Act of 1991. Recently, Supreme Court barred civil courts nationwide from registering new suits challenging the ownership of places of worship or ordering surveys of disputed religious sites until further notice. About this Act declares that the religious character of a place shall continue to be the same as it was on August 15, 1947. It says no person shall convert any place of worship of religious denomination into one different from denomination or section. It also imposes a positive obligation on state to maintain religious character of every place of worship as it existed at the time of independence. It declares that all suits, appeals, or any other proceedings regarding converting the character of a place of worship which are pending before any court or authority on August 15, 1947 will abate as soon as the law comes into force. Exemption: the Ayodhya dispute, and the Act does not apply to monuments in site covered under Ancient Monuments and Archaeological Sites and Remains Act of 1958. Any dispute that has been finally settled or disposed of, any conversion of any such place effected before such commencement of acquiescence. Penalty: Section 6 prescribes punishment of maximum 3 years and fine. Okay. Preventive detention. Jasila Shaji vs. Union of India case of 2024, Supreme Court highlighted the right of detained person to make an effective representation against preventive detention. It means detention of a person without trial and conviction by a court on a mere reasonable apprehension of him doing activity dangerous to public order. Parliament and state legislature both can make laws on preventive detention under Article 22. Constitution gives protection against arrest and detention under Article 22(1) and 22(2). These protections are not available to a person arrested or detained under preventive detention laws, which is written in Article 22 Clause 3. Constitution provisions related to preventive detention. Right to be informed of arrest grounds and presentation before magistrate within 24 hours in detention beyond requires magistrate's approval. Early notification of grounds for detention and opportunity to contest detention order. Detention beyond 3 months requires advisory board approval. These boards are set up by states and normally consist of retired judges and bureaucrats. If a parliamentary law or state law already prescribes the maximum time period of preventive detention, then this board need not constitute. If there is failure or even delay in furnishing documents relied on for such detention, it would amount to denial of right to make an effective representation under Article 22(5). Laws that permit preventive detention: National Security Act, UAPA, and these are Act. Grounds for preventive detention: security of state, foreign affairs or security of India, maintenance of public order, maintenance of supplies and essential services, and defense. Judicial pronouncement: A.K. Gopalan case of 1950, court gave a green flag to Preventive Detention Act of 1950 because of presence of explicit provisions of Article 22(5). Shubhan Lal case of 1954, SC stated that a courtroom is deemed competent to inquire into reality or in any case of the fact which are referenced as grounds of detainment. Personality rights: Delhi High Court in an interim order restrained various entities from misusing actor's name, image, voice and likeness without his consent. Personality rights: it refers to the right of a person to protect his personality, including name, voice, signature, image, and any other feature easily identified as marker of that personality. They are not expressly mentioned in any statute in India but trace to fall under right to privacy and right to property. There are two components of right to personality rights. First is right to publicity, right to protect one's image and likeness, for example through Trademarks Act of 1999 and Copyright Act of 1957. Then there is right to privacy, protection from unauthorized representation under Article 21 and with respect to the Justice K.S. Puttaswamy case of 2017. Posthumous personality rights. Defamation suit can be filed under Indian Penal Code for derogatory representation of any deceased person's reputation or their family. Emblems and Names Act of 1950 protects unauthorized use of few dignitaries' name and symbols listed in its schedule. Personality rights under international conventions. There is Rome Statute, which protects performers' rights, and then there is TRIPS Agreement of 1994, then WIPO Performance and Phonograms Treaty, judicial pronouncement, Arun Jaitley case. Popularity or fame of an individual will be no different on the internet than in reality. Deepa Jayakar case of 2019, Madras High Court said that personality, publicity and privacy rights of an individual cannot be inherited by a person's legal heir after his or her death. Then what is enemy property? Enemy Property Act of 1968 defines an enemy as a country and its citizens that commit external aggression against India, for example Pakistan, China. Enemy property is property that belongs to or was managed on behalf of the enemy. 2017 amendments expanded the definition of enemy to include legal heirs or successors of enemy, whether or not citizen of India or citizen of a country which is not an enemy. Enemy who has changed his nationality. 1968 Act empowers custodian of enemy property of India under Ministry of Home Affairs for preservation, management, control and selling of enemy properties. Right to be forgotten, also known as right to erasure, and deals with individual rights to have control of use of personal data by organization. Right to be forgotten traces its origin to right to oblivion in French jurisprudence. However, RTBF is not an absolute right. In Justice K.S. Puttaswamy case, Supreme Court recognized the right to be forgotten as part of right to life under Article 21. Digital Personal Data Protection Act of 2023 does not mention the right to be forgotten. Europe's GDPR law covers the right. Inner line permit. State government of Nagaland has approved the implementation of inner line permit in Chumokedima, Newland and Dimapur district. It is an official travel document issued by government that allows Indian citizens to travel into protected areas for a limited period. ILP system aims to regulate movement near India's international borders. It is officially used to protect tribal cultures in northeastern India. Genesis, Bengal Eastern Frontier Regulations of 1873. There are different types of ILPs, one for tourists and another for long-term stays, for example, employment purposes. State under ILP are Arunachal Pradesh, Mizoram, Nagaland, Manipur. Then not eligible for ILP, NRIs, Indians who are staying abroad for more than 6 months are not eligible. PIO card holders and OCI card holders, they will have to apply for regular protected restricted area permits. Now what is protected restricted area permits? Under foreigners order 1958, all areas falling between inner line and international borders of state has been declared protected area. Currently protected areas are located in following states: whole of Arunachal Pradesh, parts of Himachal Pradesh, J&K, Rajasthan, Uttarakhand, whole Sikkim, which is partly protected and partly restricted. Under foreigners order of 1963, areas declared as restricted areas included Andaman and Nicobar Islands, Sikkim. A foreigner is not normally allowed to visit these areas unless it is established to satisfaction of government that there are extraordinary reasons to justify the visit. Each foreigner except a citizen of Bhutan who desires to enter and stay in these areas require to obtain a special permit from a competent authority.